Welcome to The Source, where we combine the headlines with in-depth conversations with the newsmakers themselves. I'm Pinky Webb. Today on the program, the controversial anti-terrorism law faces challenges before the Supreme Court. Lawyers and groups are questioning its constitutionality and its alleged vague definition of terrorism. Despite opposition, the government says the controversial measure is needed now more than ever, assuring that activism and dissent will not fall under terrorist acts. And the upcoming vote in the House of Representatives on the renewal of ABS-CBN franchise, Albay Representative Edcel Lagman and lawyer Howard Calleja join us live. The battle against the controversial anti-terrorism law reaches the Supreme Court. Several groups and lawmakers are questioning its constitutionality. As of Monday, 4 of them have filed their petitions at the High Court. 4 others are expected to file later this week. Malacanang says it will abide by the ruling of the Supreme Court. Let's go straight to the source of this story. We have Albay 1st District Representative Edcel Lagman. Congressman Lagman, welcome to the show and thank you for your time, sir.
Good morning, Pinky, and thank you for giving me this opportunity.
Congressman, 4 groups have actually filed a petition before the Supreme Court questioning this anti-terrorism laws. And I mentioned a while ago, sir, meron pa pong ilan pa na magfa-file this week. There's so much to talk about, frankly, Congressman, but let me ask you, what is most concerning to you regarding this law?
Well, as we have said in our petition, the new law is replete with unconstitutional provisions, derogating civil liberties and fundamental freedoms, from freedom of speech and dissent to freedom of organization, as well as from privacy, protection of privacy, as well as protection from unreasonable searches and seizures, including the 24-day maximum detention of a person suspected of terrorism without a judicial warrant or without bringing the person to a judicial authority. So we are thinking, we are not
Section
against...
29, sir. Sir, let me just jump in on that. Section 29, the detention without judicial warrant of arrest. Pasensya na po, sir, we have a little bit of a delay. Puntahan ko lang po yung detention without judicial warrant of arrest. So we're looking at 24 days. Congressman, here's the thing. When you ask government or even some senators about this, they actually say that compared to other countries, tayo daw po yung may pinakamaikling detention. In fact, Secretary Anyo yesterday during my interview said it takes more than 3 days before you can actually build up a case against a suspect.
Well, the standard which we should use should not be the ones being followed by other countries, because we have our constitution. No less than the Constitution provides that even when the writ of the privilege of habeas corpus is suspended, the maximum detention is only 3 days. Otherwise, the detained person should be released if there is no charge against him. The standard should be our own constitution, not the policy of other countries. The standard should be based on our heritage of democratic institutions, not the experience of other countries. So we are submitting that 3 days is the maximum under the old Human Security Act of 2007. Even under the rules of court, it should be even less than 3 days. The maximum is 36 hours only.
So, what do you say, though? I understand, Congressman, that you're saying we're not supposed to be comparing ourselves to other countries. I do believe that yesterday in my interview, Secretary Anyo said in Indonesia it's 21 days, extendable to 120 additional days. Malaysia, 59 days, extendable to 2 years. And Singapore, 720 days. What do we say to this kind of defense, sir, that 3 days is just not enough to build up a case against a suspected terrorist, though?
Well, the case of a terrorist should even be long before detention, should already be being built up. Under the old law, any arrest should be based on prior surveillance, wiretapping, and examination of bank accounts. So even before
Mhm.
suspected terrorist is apprehended, the police intelligence should already have a background of this terrorist. So 3 days would be more than sufficient. But according to uh, security advisor Esperon, they are now preparing the list. Why only now? They should have prepared that list long time ago. How can you apprehend a terrorist when there is no wanted list? If they're preparing that just now, then it's the enoughness of military intelligence, not the weakness of the old law.
Then, Congressman Lagman, basically what you're also saying is that there should have been, number one, you're basically saying there should have been a case build up prior to the arrest, and that maybe, are you saying, sir, that the intelligence unit must do a better job so that the 3 day detention period will suffice?
Yes, and definitely they should not waste intelligence funds being appropriated in millions of pesos because that is their task to make a really foolproof study and preparation even before apprehension is made.
There's another, I think in your petition, Congressman, you actually use the word chilling effect. And I think this had to do with the criminalization of threat, proposal, and inciting to commit terrorism. Tell us more about that, Congressman.
Well, the chilling effect is with respect to the derogation by prior restraint of the freedom of expression. And the chilling effect is quoted from many Supreme Court decisions, both in the Philippines and in the United States, because that is the prior restraint. That is a mode of silencing critics. That is a way of preventing them from exercising the right of uh, free expression and dissent. And I would like to go to the statement of National Security Advisor Esperon, and I quote, he said, if you are silent, then you won't be harmed. You have no reason to complain. Well, precisely, this is the horrific message being sent by the law. It is to silence people. It is to suppress their freedom to dissent. It is a way of silencing the citizens to submission and oblivion. This is precisely the gravamen of the unconstitutionality of this law, among so many others.
Congressman, when they say, though, that activism is not terrorism and freedom of expression and freedom of assembly will be respected, is that not enough when they tell us that no, you can protest, there can be dissent, and that will not be categorized as terrorism?
Well, that is the say-so of the supposed implementers of the law. But no amount of assurances that there will be a faithful implementation of the law will mitigate the incidence of abuses, because it is in the law itself where the abuse is encoded. So we have to remove, excise those unconstitutional provisions in the law, because it is the law which is abusive, and this will embolden law enforcers to make arbitrary implementation of the law, which would violate fundamental freedoms.
I think it's in Section 4, Congressman, where it tells us the acts of terrorism. There are a number, engages in acts that cause death or serious bodily injury to any person or endangers a life, develops manufacturers, uses weapons, explosives, etc., sir. But when you talk to the proponents, they always say that this seems to be not highlighted, provided that terrorism in this section shall not include advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights which are not intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety. Isn't this enough, Congressman?
Well, if the provision would end there, then that can be adequate. But we should continue reading the provision, because there is a killer caveat which says that all of these concessions to advocacy in dissent would be nothing if the acts are intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk to public safety. This is what we call the killer proviso. All that a law enforcer or prosecutor would have to do is to invoke the killer proviso, and that would stifle dissent. That will suppress freedom of expression. So that killer provision should have been deleted, so that the concession to advocacy and dissent should be paramount.
So if I take it, understand how you said, Congressman, that was okay. Wag lang sana nilagay yung which are intended to cause death or serious physical harm to a person, to endanger a person's life, or to create serious risk to public safety. If you're saying kung tinanggal po yon, this could have been a good enough safeguard?
Yes, because that would be a thorough acknowledgement of the right to advocate and to dissent. But that has been decimated by the killer provision. This is the torpedo which destroys all concessions to civil liberty, to civil liberties and fundamental freedoms. So we should we should appreciate and know the malicious intent embedded in the law.
All right. Congressman, before I let you go, I just want to get your thoughts on the hearings on the franchise of ABS-CBN yesterday. What was tackled was supposed to be the alleged bias reporting of ABS-CBN. Some say this actually infringes on, certain provisions, of course, also freedom of speech, etc., sir. What are your thoughts on how the proceedings are actually happening?
Well, I think the long drawn out proceedings would be terminated by Thursday, because on Thursday there will be a summation by the respective parties. It is my personal assessment, Pinky, that all of the issues taken up by the joint committees would be in favor of ABS-CBN, from the citizenship requirement up to the issuance of PDRs, including the fact that there is a certification by BAR and other agencies that ABS-CBN has no tax liability or does not have any unpaid taxes or tariffs, and also the statement that there is no case pending in the COMELEC or other courts which would ensnare ABS-CBN into culpability in violating the Fair Election Act. As a matter of fact, Pinky, the Fair Election Act allows TV networks to meddle in politics. Because according to the Supreme Court, in the case of ABS-CBN versus COMELEC, it is during the time of the election campaign that we should give primacy, more primacy, to the freedom of the press so that the information to the electorate would be maximized.
I see. Congressman, when will the vote happen?
Well, I think that will have to be scheduled most probably by next week because the last day of the hearing will be Thursday. Then by next week, it's right for voting. And the speaker said that there should be a conscience vote by members of the committee as well as the members in plenary.
I see. So just as a last question, Congressman, if it happens next week, sir, everyone, all members of the House of Representatives will be voting?
No, not yet. Only the members of the
I see.
The Committee on Legislative Franchises will vote whether or not to renew or give a new franchise to ABS-CBN. The voting in the plenary will come later after a committee report is rendered by the Committee on Legislative Franchises.
Maraming salamat po sa inyo, Congressman Edcel Lagman. Stay safe, sir.
Thank you. Thank you very much again for this opportunity to express these views.
And we'll be taking a short break. We'll speak to another petitioner of the anti-terrorism law. Attorney Howard Calleja will join us after the break.